Good afternoon, everyone. My name is Scott Gerber, and I'm pleased to moderate today's AALS Constitutional Law section panel on new books in constitutional law. Law professors don't just publish articles in edited law journals anymore. More and more of us publish books, including the four talented presenters for today's webinar. Those presenters are Kermit Roosevelt of Penn, Ilya Somin of George Mason, Michael Mannheimer of Northern Kentucky, and Samantha Barbas of Buffalo. As you'll soon see, Professor Roosevelt's book, The Nation That Never Was, offers a powerful and inspirational rethinking of our country's history and uncovers a shared past that we can be proud to claim and use as a foundation to work toward a country that fully embodies equality for all. Professor Somin's Free to Move discusses how broadening opportunities for foot voting can greatly enhance political liberty for millions of people around the world. Professor Mannheimer's The Fourth Amendment chronicles how the court's misinterpretation of the Fourth and 14th Amendments has led them to hold federal and state law enforcement to the same constitutional standards. And Professor Barbas's Actual Malice tells the full story of New York Times versus Sullivan by drawing on previously unexplored sources, including the archives of the New York Times Company and civil rights leaders. In terms of format, I'm just going to go in the order that I just read, which I drew randomly. Each presenter will have 22 minutes or so to make a presentation, and I'll go through all four presenters, and then after that, we'll have about a half an hour for questions from the audience. And in terms of how you ask your questions, you can do it in a variety of ways. You can put it in the chat. You can use the raised hand function on your Zoom window, or you could literally, I suppose, just raise your hand like I'm doing, and I will do my best to call on everyone in the order that I see them wishing to participate. So with that said, I'd like to turn it over to Professor Roosevelt.
Thank you so much, Scott. Let me first start by thanking you for setting this up and doing the work of organizing it. And thank you also to the AALS for hosting it. And of course, thank you to everyone who's watching. So I'm going to talk about this book. And basically, what is it about? It's about American values and where they come from and what the story of America is. And part of what I'm saying here is going to be pretty familiar, I think, and then part of it is novel and maybe surprising, and possibly different parts will be surprising for different people. But what is our basic value as Americans? I would say equality, with some important qualifications. That what I mean by that is universal equality under law, so equality for all people, and equality in the sense that the government is supposed to treat you equally, or at least with equal concern and respect. Maybe there are relevant differences among people, so differential treatment could be appropriate, but everyone is of inherent equal worth or dignity. So that's supposed to be a familiar idea. Now, where does this value come from? The standard answer is the Declaration of Independence, and in particular, the phrase, all men are created equal. And in this book, I say yes to that, sort of with an asterisk. The asterisk being, this is what Martin Luther King means in 1963, when he invokes it in the March on Washington, I Have a Dream speech. It's what Abraham Lincoln means in 1863, when he invokes it in the Gettysburg Address, but it's not what Thomas Jefferson means when he writes that phrase in 1776. So what does Jefferson mean? He means basically there is no divine right of kings. He's tracking Locke's second treatise on government. He's talking about the state of nature, a hypothetical world with no government and no laws. And he's saying if people popped into being, if they were created in the state of nature, hypothetical people, there would be no legitimate political authority. No one would have an obligation to obey anyone else. And why does Thomas Jefferson care about that rather than our modern understanding? Because the Declaration of Independence, to a degree that we tend to forget nowadays, is really about independence. That is, secession. It's about when political authority that was legitimate ceases to be, when it loses its force and can be rejected. So it's about the relationship between people and the governments that they create to protect their own rights, when they don't have to obey those governments anymore. And importantly, it is not about the relationship between governments and outsiders. So it says something about how the government has to treat the people who create it. Doesn't have to treat them equally. That kind of equality is not in the Declaration at all. But it does have to protect their natural rights. If it doesn't, it loses its legitimacy, its authority can be rejected. That's the argument that the Declaration goes on to make about King George. But it's not saying anything about how the government should treat people who aren't part of that social contract, who didn't consent to the government's authority. So it doesn't tell you, for instance, that the government shouldn't enslave outsiders. That is a question that the Declaration just doesn't address. So the Declaration, as it's understood in 1776, isn't theoretically, philosophically inconsistent with enslaving outsiders. It does condemn what the colonists allege King George is doing, trying to make them slaves, that's their argument, because they are insiders. But it doesn't condemn what the colonists themselves are doing, enslaving outsiders. Now, we understand it very differently today. And some people understood it differently close to 1776 too, right? You see abolitionist readings of the Declaration pretty early. But the key question is, are these the founding fathers, people like Thomas Jefferson, or are they more the dissenters and the marginal voices? And my claim is they are the dissenters. And a good, vivid illustration of this, I think, is the correspondence between Benjamin Banneker and Thomas Jefferson. So Banneker writes to Jefferson in 1791. He says, here's some astronomy problems I've been working on that you might find interesting. And by the way, you wrote all men are created equal. Don't you think that means we should abolish slavery? And Jefferson writes back, says some polite things, thanks for the astronomy, very impressive, but says not a word about this interpretation of all men are created equal. So if you're looking for our modern reading of the Declaration in early America, and you're like, the founding fathers are saying this, Benjamin Banneker is putting it out there, but Thomas Jefferson is not picking it up. And if you think about the history, the idea that the Declaration is broadly anti-slavery really makes no sense. And there are lots of reasons for that, but here are a few. A general attack on slavery is not necessary to the argument of the Declaration. Abraham Lincoln famously noted this, but then he sort of tried to wave it away, saying it was put there for future use. But it's also counterproductive, right? A general attack on slavery makes the colonists look like wrongdoers. So it's not a great start to the argument. If all men are created equal had been understood as critical of slavery in general, the Continental Congress would almost certainly have taken it out, because they did take out Jefferson's criticism of the international slave trade. And if all men are created equal had been understood as critical of slavery, the preamble probably would have attracted more attention than it did in 1776. It actually wasn't considered important or striking at the time. Pauline Maier documents this brilliantly, because it was basically seen as just a recapitulation of Locke's second treatise. So I'm saying founding America, the America of 1776, doesn't state our modern ideal of equality in the Declaration. Now, I admit founding America is diverse, right? Founding America is a they, not an it. And some people do believe something like what we do now very early. But when founding America is an it, when it speaks with one voice, it tends to say pro-slavery things. So that would be the Declaration, for instance, which ends with complaints about domestic insurrections. Or it would be the Treaty of Paris, which ends the Revolutionary War, with the demand that the British not carry away any Negroes or other property of the Americans. Or it would be the Constitution written in 1787, which has the Three-Fifths Compromise and the Fugitive Slave Clause and the protection of the international slave trade until 1808. So another thing I say is we tend to get the founding Constitution wrong, almost as fundamentally as we get the Declaration wrong, because we make a sort of category mistake with it. We think the founders wrote the Declaration and they were saying something about what governments should do, which is protect the natural rights of the people who made them. And that's actually true. But then we go on and we say, and they wrote the Constitution to create a government guided by the theory of the Declaration. And that's actually not true. So there are American governments in 1790 that are guided by the spirit of the Declaration. And those are governments that are supposed to protect the natural rights of the people who form them. Those are the state governments. The federal government created by the Constitution is a very different kind of government. And you can see that just by looking at the federal government and the Constitution, because the point of declaration-style governments is protect people's natural rights, which means protect individuals from other individuals. And there's not a single provision in the Constitution as of 1791 or as of 1861, if you want to look forward to there, that restricts what one individual can do to another. The Constitution doesn't protect individuals' natural rights from other individuals. And the federal government that the Constitution creates doesn't do that either. It couldn't then, it can't now make it a crime for one American to kill another. The sort of most basic protection of your natural rights, protection of your life, absent some special circumstances that make it a matter of federal concern. So in 1791, we've got a declaration that's generally understood to be about secession, and a constitution that's really focused on what Akhil Amar calls geostrategic concerns. It leaves individual to individual relations basically up to the states. But there are other people with different visions who don't want to leave this up to the states because they think some states are doing a really bad job of protecting natural rights, and these are the abolitionists. So I'm saying American values get articulated first by abolitionists. They're the product of dissent, which is sort of what we like to tell ourselves, but it's not dissent from Britain. It's not the struggle against monarchy. It's dissent from founding America. It's the struggle against slavery. And I think that's actually better in terms of telling an inspiring story. So there's a clash of values. People are fighting about it. Eventually, the anti-slavery Republican Party captures the presidency with Lincoln, and the South secedes. And then Lincoln, in the Gettysburg Address, tells us he's fighting for the America of 1776 and the Declaration, which is all about equality. And this no longer seems surprising or novel to me, but maybe it will to you. Lincoln has that totally backwards, because he is fighting against people who have declared their independence, who have invoked the Declaration of Independence as support. And the Declaration is about exactly what they're doing. It's about when people who have been connected by political bonds can dissolve them and separate. It's about secession. And the claim of the Southern states is, we consented to a government that protected slavery, and now you've turned against it, and we think we would be better off with an emphatically pro-slavery government, so we're going to go our own way and make that. And I think they are right that the Declaration supports them, and Lincoln is wrong. So what that means is, I think we should think differently about the Civil War. We shouldn't think about it as the completion of the Revolution, right? A war against this deviant institution of slavery that's contrary to the principles of the Declaration and somehow sprang up in America. We should think about it as something more like a repudiation of the Revolution, a rejection of the idea of independence and secession, most obviously. And we should think about Reconstruction differently in much the same way. So our conventional wisdom, which was vividly on display in the affirmative action case, is Reconstruction is a second founding that completes the 1791 Constitution basically by adding in the principles of the Declaration. And there's some truth to that, because it is during Reconstruction that the federal government starts protecting the natural rights of individuals, which is what the governments described in the Declaration are supposed to do. But again, this is not a completion of the 1791 Constitution as much as a rejection. So it's a rejection of slavery, which the 1791 Constitution protected. It's a rejection of state authority over membership in their political communities. And it's a rejection of the idea that there's a racial line around the American national political community, which is how Dred Scott read the 1791 Constitution. And it's doing all of this against the will of the former Confederate states, without their consent. So the 14th Amendment only gets ratified because Congress wipes out the government of 10 states that rejected it, and then made new governments that would accept it. And that, too, I think is pretty anti-founding. Dissolving our legislatures is actually one of the complaints that the Declaration makes against King George. So is freeing the people that we enslave. And then in terms of the broader question, how the state and federal governments are supposed to relate, I always like to look at Federalist 46, where Madison says the state governments will always be more important and they will defeat the national government in war if necessary. It would be a replay of the Revolution. And I'm saying the Civil War is a replay of the Revolution, right? 13 states fight against the national government. But in the Second American Revolution, the rebels lost. The rebels lost, but I also say the revolutionaries won, because Reconstruction is a revolution that sweeps away the political order of founding America. And the easiest way to see that, I think, is the treatment of claims based on emancipation. So the 14th Amendment says all such claims are illegal and void, just like Confederate debt. It's in the same sentence. There shall be no claims based on rebel debt. There shall be no claims based on emancipation. So that is uncompensated immediate emancipation, which doesn't seem radical now because it's so obviously the right thing to do. But the point here is uncompensated emancipation is better understood as the overthrow of a slaveholding regime than reformation. So if you want to reform a slaveholding regime while maintaining your political order, I think you do what the northern states did before the Civil War. You abolish gradually, you pay compensation because you recognize you're taking away rights that exist under valid laws. And even in 1862, when Congress abolished slavery in DC, they paid compensation. But by 1868, things have changed. 14th Amendment wipes away the laws of slavery as if they were no more valid than rebel debt. And I think people look at that now and say, well, of course, right? We reject rebel debt because the Confederacy was never a legitimate government, and we reject the Confederate laws of slavery too for just the same reason. But my point is, if you want to associate the laws of slavery with a particular political regime, it's actually not the Confederacy. It's more founding America. Because the Confederate states, of course, had those laws before secession. Every state had them in 1776. And states that stayed in the Union had them in 1868. Delaware, Maryland, Kentucky, Missouri. And then they were all wiped away by this revolution that I described. And the regime that's being overthrown is less the Confederacy and more founding America. So the upshot of all of this is I'm trying to shift our understanding of our origins from the founding to Reconstruction. And I'm trying to say the relationship between those moments is not progress and completion, but more rejection and overthrow. So that's a different story. And I think it's a better one because I do think that it's more inspiring, right? We want to say, I think America is an anti-slavery nation and has been since its birth. And I think that's true, but not quite in the way that we normally tell the story. So I would say we weren't anti-slavery until 1863, and we weren't a nation until 1868. Not a single nation. You can look at like whether the United States is a singular or plural phrase, for instance, to figure that out. Although even in the 14th Amendment, even the Reconstruction Amendments use it as a plural. But that said, I also want to say there are structural similarities between the story that I'm telling and the standard story. So the standard one says, we start with a short document that states our ideals. And that's nice because people can memorize it. That's the Declaration of Independence, right? And people do memorize it, although they usually only memorize the preamble. And I'm saying, no, right? We can replace that with a short document that states our ideals. It's the Gettysburg Address. And people memorize that, and they memorize the whole thing, and you don't run into complaints about domestic insurrections at the end. Standard story says, then we fight a war for those ideals, which is the revolution. And I'm saying, then we fight a war for those ideals, but it's the Civil War. Which is better, I think, because that's really an anti-slavery war, which the revolution is not. And it's actually, I think, black military service in the Civil War that kind of gives us our modern constitutional order. Because it's black military service that makes black citizenship inevitable, and it's black citizenship that requires the 14th Amendment. So now we've got a real multiracial origin story, which the founding is not so much. And then the standard story says we've got a longer document that makes these ideals into law. It's the 1791 Constitution. And I'm saying, no, it's the Reconstruction Constitution with the 13th, 14th, and 15th Amendments. And I've said the 1791 Constitution doesn't really embody the principles of the Declaration in terms of protecting the natural rights of individuals, but the Reconstruction Amendments do. At least they go a lot farther in that direction. So I think it's a better story for various reasons. But if I had to boil them down, my basic argument is this is both more accurate and more inspiring. Right? It's more true and it's more useful. It can do a better job of bringing us together in service to the values that we say we believe in. Thank you.
Well, thank you, Kermit. One benefit of being the moderator is I have 4 free books, and I enjoy them all. We have some questions in there, but on the chat, but as I said, I'm going to wait until the end to get to those. So right now I'm going to turn it over to my friend Ilya Somin of George Mason.
Hey, thanks to Scott for organizing and moderating this event, and to AALS for hosting it. I'm in a moment going to share my screen so that I can start the presentation. And I'm also going to see if I can put this thing in slideshow mode so it can actually technical. There we go. Okay. Great. And then let's see if I can move this away. Okay. So my presentation is about my book, Free to Move: Foot Voting, Migration, and Political Freedom. Ironically, the original edition of this book came out in April of 2020, right as much of the world was going into lockdown, which, however, did give me the opportunity to write a revised edition, which came out last year, which, among other things, incorporated some of the lessons of the COVID pandemic. If anything positive comes out of the horror that we experienced, perhaps it might be a new appreciation for the virtues of freedom of movement, which many of us who normally have it often did not during the pandemic. In the book, I argued that expanding people's ability to vote with their feet can massively increase political liberty and human welfare of all kinds, particularly, but certainly not exclusively, for the poor and disadvantaged throughout the world and within the United States as well. So I'll start out by first talking about the 3 types of foot voting that I consider in the book. One is simply foot voting within a federal system, where we choose where to live in a state or a local government, at least in part based on the government policies that prevail there and how much we like them. Then there's also voting with your feet in the private sector, which I will say a bit more about later. And finally, and most controversially, foot voting through international migration. And I will suggest that all 3 of these have enormous advantages. And in the latter part of the talk, I will discuss how constitutional institutions can be structured in ways to maximize opportunities for foot voting, while also addressing some potential downsides. But first things first, why should we even care about foot voting as a mechanism of political choice when most of us probably think the way we make political choices, we go to the ballot box. We vote for the Democrats or the Republicans or Joe Biden or Donald Trump or whatever other candidate we might prefer. And I think this is true to some extent. There's obviously value to political choice at the ballot box, but it has 2 significant limitations. One is that when you vote at the ballot box, the likelihood that your vote will make a difference is infinitesimally small. In a presidential election, it's about 1 in 60 million. Even in a state election or a local one, the odds of decisiveness are very, very low. In most cases, we would not say that you have meaningful freedom of choice if you have only a 1 in 60 million or even a 1 in 1 million chance of making a difference. We would not, for example, say that you have meaningful freedom of speech if you have only a 1 in 1 million chance of being able to determine what opinions you can express, or that you have meaningful freedom of religion if you have only a 1 in 1 million chance of being able to determine what faith you want to practice or whether you want to practice one at all. And I would suggest the same thing is true of political choice. There's not much in the way of meaningful political freedom if you have only an infinitesimal chance of being able to influence the policies that you live under. And this leads us to the second and closely related weakness of ballot box voting, which is that precisely because there is so little chance that your vote will make a decisive difference, voters have incentives to be rationally ignorant. That is, they spend very little time and effort paying attention to the government policies they're voting on, to the candidates and their positions and so on. In this book and in my previous book, Democracy and Political Ignorance, I go through many examples of this type of ignorance. I'll just mention one or two. Surveys consistently show that only 1/3 to 1/2 of Americans can even name the three branches of the federal government: the executive, the legislative, and the judicial. Most of them don't know such basic things as how the federal government spends its money or which government officials are responsible for which issues. And this is an example of the kind of rational ignorance that I was talking about. The American Medical Association says that before a doctor can treat you, they have to get your informed consent. Like medical treatment, government policy is often literally a matter of life and death. It makes a huge difference to our welfare and happiness and liberty. Yet most of the time, democratic government is like a doctor whose treatments you cannot refuse. And most of the patients have little or no ability to figure out whether the treatments are actually working or whether instead they're a form of snake oil. In the book, I talk in more detail about how these weaknesses of foot voting, or ballot box voting rather, are significant from the standpoint of a wide range of theories of political freedom. I'm happy to go into the details of those in questions. For now, I will merely say that foot voting is significantly superior on both of these dimensions. If you're allowed to vote with your feet, that is a decisive choice that is likely to make a difference if you move from one state to another or one locality to another, and thereby end up with different government policies than you had in your previous location. That is a decisively significant choice. And for that very reason, a wide range of different kinds of evidence shows that when people vote with their feet through international migration, in a federal system, or in the private sector, they're generally much better informed than when they vote at the ballot box. And these two facets of the superiority of foot voting are very significant from a wide range of different moral theories. I'll now take a closer look at the three types of foot voting, starting with the most familiar, foot voting in a federal system. In the United States, we have 50 state governments and many thousands of local governments. And this gives foot voters a wide range of potential options, much more than you get just by voting for the Democrats or Republicans at the national level. Historically, foot voting in the federal system has been a particular boon to the poor and the disadvantaged. The most famous example, perhaps, is African Americans fleeing the Jim Crow era South, but there are many more examples throughout our history. In recent years, some obstacles have arisen to make this kind of foot voting more difficult, the biggest being exclusionary zoning, which makes it very difficult to build new housing in response to demand in many areas, and thereby makes it hard for people who would otherwise find opportunity to move there. In the book, I propose a variety of reforms to reduce these barriers to movement, particularly zoning, but also some others. I also discuss some potential limitations, such as moving costs and some others. I'm happy to talk about that in question. But even in the status quo, there are tremendous opportunities for foot voting, and we can have them to a much greater extent within our federal system by reforming some of the negative aspects of the status quo. A less familiar idea than foot voting in a federal system is foot voting in the private sector. But in fact, there are many organizations in the private sector that provide goods and services traditionally associated with local or even state governments. The most common are private planned communities, like condominium associations, homeowners associations, and others. Over 70 million Americans already live in these kinds of entities, so it is not true that they are limited purely to the wealthy or the advantaged, unless you think we have over 70 million very wealthy people in the US, which by and large we do not, unfortunately. And It is the case that private planned communities can offer greater freedom of choice even than foot voting between state and local governments. There's many more of them. There's many more options. Also, the moving costs often are likely to be lower. Nonetheless, although this form of foot voting is already widespread, there are various reforms that we can undertake to make it more available to more people, particularly the less affluent. In the book, I discuss those reforms and possibilities in some detail. It is not my contention that foot voting in the private sector or within state and local governments can fully displace all of the functions that currently exist in the federal government, but much more can be decentralized to these entities than is currently the case. To take just one obvious example, many American states and localities are as big or bigger than most European countries. If you believe those entities can have their own healthcare policies, their own education policies, and so on, then the same is true of Virginia or Massachusetts or Texas or California, or even many American cities, which are pretty sizable as well. It is also true that various private organizations, including planned communities, can take on many functions traditionally associated with local governments. The most controversial form of foot voting, certainly in American politics, is that through international migration. But nonetheless, this is the kind that has the biggest potential benefits. The reason for that is the enormous variation in the quality of government between countries, which is far greater than anything found within a country. Think of whatever you believe is the best governed American state versus whatever you believe is the worst one. It's probably a pretty significant difference, but nonetheless, it's nowhere near as great as the difference between the US and Cuba, or the US and Haiti, or the US and any number of horrific dictatorships that exist around the world. And as a result, if you allow more of this kind of foot voting, you get much more in the way of freedom and opportunity of almost every kind for millions of people, including people who are among the most oppressed throughout the world. I would add that for the 1/3 to 1/2 of the world's population that lives under dictatorships, foot voting through international migration is virtually the only realistic political choice that they can hope to exercise, in many cases within their entire lifetimes. So there's a major element of expanding political freedom here as well that goes beyond anything that happens internally within Western liberal democracies. In the book, I go into detail on two types of objections to expanding foot voting. One is the idea that governments have an inherent right to keep people out, either because of ethnic self-determination or because of a kind of property right. Another is that there is a right or a desirability of keeping people out to avoid various specific types of negative side effects. I'm happy to talk about both of these kinds of arguments in greater detail in the question, but for now, since this is a constitutional law forum, I'd like to go on to the implications for constitutional structure and constitutional design. One is that we can design federal systems in ways that facilitate foot voting. The most obvious way to do this is to limit central government power so that more issues are handled at the state or local level, and thus more are available for foot voting. In addition, foot voting in state and local government is enhanced if they're incentivized to compete for residents, and there's various things we can do to incentivize that kind of competition. The biggest is hard budget constraints. If states and localities have to raise a high percentage of their funds from their own taxpayers, that gives them incentives to attract more taxpayers, promote more economic development, and so on. There's also limitations on conditional grants to state and local governments that can also help with this that I can talk about in more detail in questions. There are also constitutional individual rights that are extremely important for facilitating foot voting. The most obvious is freedom of movement between states and localities. We take this for granted today, but as I'm sure Kermit Roosevelt will be happy to explain, before the Civil War, it was actually common for states to restrict freedom of movement in various ways, particularly for Blacks, but even sometimes for poor whites as well. And even today, there are occasional efforts to do things of this sort. In addition, there are other types of individual rights that promote foot voting as well. Speech and religion rights make the flow of information easier and thereby enhance people's ability to vote with their feet because they know about the options. Certain kinds of non-discrimination make it easier as well by preventing states from indirectly essentially excluding people by discriminating against them. And then one that I think is not sufficiently recognized is constitutional property rights. I mentioned exclusionary zoning before. Stronger protection for property rights would make it easier for people to build new housing on their land, which in turn would make foot voting easier. Also, more restrictions on the use of eminent domain would make it harder for localities to, in effect, expel people by condemning their homes and forcing them out, something of which we have, unfortunately, a very sad history, particularly in the era of urban renewal, but in some places, even today. And there are a number of other individual rights that can help in this area as well. Finally, sorry, having technical difficulties. It's worth noting the ways in which constitutional structure can help expand opportunities for international migration, which in some ways is the most powerful and most compelling form of foot voting. One is we can have tighter limitations on the federal government's power to exclude. One of the most badly flawed decisions in the history of the Supreme Court is the Chinese exclusion case of 1889, which ruled that the federal government has a near absolute power to exclude migrants, even though no such power is actually enumerated in the Constitution, and even though both the court's decision and the Chinese Exclusion Act itself was heavily motivated by racial prejudice of various kinds. It would be worth reconsidering this from a variety of points of view, but one of them is that it severely restricts political freedom and foot voting, including for many of the most oppressed people in the world. A less expansive but still significant form of reform is to at least say that even if the federal government does have the power to exclude migrants, it at least should be limited by individual rights provisions of the Constitution. Sadly, the Supreme Court has ruled and reaffirmed most recently in the Trump travel ban case of 2018 that most individual rights constraints that apply to other forms of federal exercises of power do not apply to laws that exclude immigrants. And so Trump was able to get away from what was clearly a policy motivated by religious discrimination, which would have surely been struck down in almost any other context. And there are many other individual rights that are taken for granted in other contexts, which go by the wayside largely when it comes to immigration restrictions. In addition, we could potentially do what a number of other federal systems do, like Canada, Australia, and some others, and allow states and local governments to admit migrants that otherwise might have been excluded. There are actually proposals to do this that have been put forward by both Democrats and Republicans, but sadly, so far at least, not enacted. And then finally, there are various ways in which government can be structured and constitutional systems can be structured to minimize possible downsides of migration. For instance, if you worry that immigrants will be bad voters, well, you can do what we to some extent already do. And there's a rule that they cannot become citizens for at least 5 years. And even then, they must pass a civics test that most native-born Americans would fail if they had to take it. much more can be said, and I do in fact say much more in the book. But for now, I conclude, and I very much look forward to your questions and the discussion. Thank you so much. And I'm going to stop sharing.
Okay, well, thank you very much, Ilya.
I'm
And as
trying to
soon as
stop my
you
sharing,
stop
but-
sharing, I will turn it over to the next.
So I pressed pause share, but I don't see a button that lets me stop the sharing.
I think it's at the top. Maybe Shannon could help us. Wait, here you go. I've done it for you.
Great.
All right. So I appreciated that. That was very interesting. Now we're going to hear from Michael Mannheimer, and he's written a new book about the Fourth Amendment. So go ahead, Michael. Thank you.
Thank you. I had some technical difficulties, but I'm back. Hopefully that won't happen again. Let me get my PowerPoint back up on my screen. There it is. And bear with me. I'm going to share. Okay, can everybody see that? Let me start the slideshow. Everything good? Okay. Thank you. Hopefully I won't. I specifically, I'm staying in New York, and I specifically asked folks at Cardozo Law School to lend me an office so I would have good internet access. And they graciously did, but hopefully we won't have that kind of a glitch again while I'm talking. So thank you so much to Scott and to AALS for putting this together and giving me the opportunity to speak about my book. I am, primarily a criminal procedure scholar, but what we call criminal procedure is really a branch of constitutional law. As Akil Amar said, and Arthur Wilmarth said before him, and probably someone said before him, we kind of divide up the Constitution in law school so much that it's a little bit like the six blind men, looking at the elephant. I try to, take off the blindfold a little bit and kind of look at the Fourth Amendment, but also look at the Fourth Amendment through the lens of the 14th Amendment. So the challenge of the book is to talk about what this and this have to do with this. This is James Otis arguing the writs of assistance case in Paxton's case in 1761 in Massachusetts Superior Court in Boston, which many people know about. This is an auction of the services of a Black Southerner, not as you would suspect before the Civil War, but after the Civil War, 1866 in Florida, under the convict leasing system that essentially was a replacement for slavery. And then what does that have to do? What do both of those things have to do with modern policing? So the thesis of the book is that when we talk about original understandings, we pay too much attention, far too much attention to 1791. And in some respects, there's some overlap here between my book and Kim's, and not enough attention to 1868. Since most policing is at the state and the local level, it's the 14th Amendment, not really the Fourth Amendment, that applies directly. And through the legal fiction of incorporation with the Bill of Rights, we pretend that the Fourth Amendment applies directly, and that it's the text of and history behind the Fourth Amendment that matters, when it's really the text of and history behind the 14th Amendment that matters most. So in the book, let me go back a sec. In the book, part one is sort of this. The first 5 chapters is original understandings of the Fourth Amendment, and then chapters 6 through 8, I go through the 14th Amendment, and then chapters 9 through 11, the last part of the book, is more about how we should look at modern policing, given the premises of the first 2 parts of the book. So the Fourth Amendment, of course, says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, etc. The two main ways of looking at the Fourth Amendment are the sort of the warrants view, which is, I guess, the more liberal view or the more conventional liberal view that warrants are required for searches and seizures unless you can't get one. The other view, the reasonableness view, touted by folks like Akhil Amar and Justice Scalia, is that warrants are not the default. General reasonableness is the default. You should just look to sort of generalized notions of reasonableness. And what I say is that they're both wrong. And what the Fourth Amendment itself really was about local control of search and seizure policy, and unreasonable searches and seizures are those that are in violation of state law. Remember, the Fourth Amendment only applies to the federal government. So search and seizure law was largely enforced through state tort law. Search and seizure rules differed by state, and more importantly, the founders understood that they did, at least the anti-federalists did. I think they all really did. But what the Fourth Amendment does, it's like a savings clause. It preserves state law rights and remedies when federal agents search and seize in violation of state law. It says that Congress can't override state law when it comes to searches and seizures. So they wouldn't have spoken of federal agents violating the Fourth Amendment. That's a modern locution. We talk about violations of the Fourth Amendment by police officers. That would have been nonsensical to them. Only Congress can violate the Fourth Amendment. What federal agents can do is violate state law, and what Congress can't do is to immunize them from suit and authorize general warrants. This is consistent with colonial arguments and actions during the writs of assistance controversy. I look at that in chapter 2 of the book. I talk about search and seizure law differing by state in chapter 5 of the book. And it's also consistent with the views of the anti-federalists, which I talk about in chapter 3. These were the opponents of the Constitution. They demanded a Bill of Rights. Everybody knows, I'm just kind of refreshing everyone's recollection here. And it was their acquiescence to union with the cost of a Bill of Rights that gave us the country that we know. So scholars and judges are starting last decade and a half or so to recognize the importance of the anti-federalists in interpreting the Bill of Rights. Certainly a new crop of federal appeals judges are recognizing that more and more. So if the Fourth Amendment, and I'm kind of breezing past this part 1 because I want to get to part 2 and part 3. If the Fourth Amendment is mostly about federalism, well, how can we incorporate it? So I kind of question jot for jot, total incorporation. And so starting with chapter 6, I talk about, well, why do we have the 14th Amendment? We have the 14th Amendment for 2 basic reasons. Because of Northern outrage over the Southern Black codes, which comprised race-conscious laws, but also race-neutral laws that were enforced discriminatorily. And the prime example of that are the vagrancy statutes, which were race-neutral on their face, but were enforced almost exclusively against Southern Blacks. And then there was Southern violence against Black people and loyal white people in the South, and Northerners relocated in the South, primarily Black people. The Southerners reserved their greatest ire for Southern Blacks who had fought as Union soldiers. So there was private violence that was sort of acquiesced in by the state, but there's also state violence. So these were the 2 drivers behind the ratification of the 14th Amendment. So given the background, does the 14th Amendment incorporate the Fourth? And my answer is yes, with a but. Yes, the consensus was that the states would now be bound by the rights in the Bill of Rights, including, or at least some of the rights in the Bill of Rights, including the Fourth Amendment. But they also said that our basic federal structure would remain intact, and that most decisions about civil rights would be made at the state level. It was the states who were still responsible for protecting civil rights. And that the Privileges or Immunities Clause would not even apply in states that provided basic civil rights. So it wasn't so much about the federal government protecting these rights themselves in the first instance. It was sort of a federal requirement that the states protect these rights, and the federal government would step in when the states failed to do so. So that it sounds a little bit contradictory, I guess, that there is a consensus that there's incorporation, but there's still, federalism, and it would be mostly the states protecting rights. So we have to, the chapter 8, I think, is where the rubber hits the road on incorporation. We have to kind of talk about 3 different tensions here. There's the Fourth Amendment as a structural provision versus the Fourth Amendment as a rights provision, and it's both, right? It's a structural provision, it's a federalism provision, but the ultimate object is to protect rights. It protects rights by calibrating what federal agents do to what state agents can do, and so we have to kind of think about that as more as a rights provision when it comes to the 14th Amendment. And then there's meshing 2 very different legal and political philosophies of the anti-federalists who fought for the Bill of Rights and the Reconstruction era Republicans. And I won't get into the nitty-gritty because I can't get into the weeds too much given time constraints, but they had very different legal philosophies. They had very different political philosophies, almost diametrically opposed to one another. The anti-federalists, of course, were the ancestors of the Democrats, first the Jeffersonian Republicans, Democratic Republicans, and then the Democrats. The Reconstruction era Republicans were obviously the descendants of the Federalists. So these are parties on different sides of the line. And then another paradox we have to resolve or think about is ensuring rights, like I said, while preserving federalism. So how do we do that? Well, how do we resolve this tension of the Fourth Amendment as a structural provision versus the Fourth Amendment as a rights provision? Well, I borrow a page from Akhil Amar and I talk about refined incorporation. We have to distill the core protection of the Fourth Amendment, which is freedom from arbitrary searches and seizures. That's really the core of what the Fourth Amendment is about, and you can protect that freedom in numerous different ways. How do we mesh these 2 very different legal philosophies? Well, we require states to recognize natural rights, yes, without requiring any particular manifestation in positive law of those rights. Right? There's a difference between saying that the states have to recognize this natural right and saying they have to have a particular way of doing so. We leave a lot of leeway to the states to decide how to protect those natural rights. And then the tension between rights and federalism. Well, federalism doesn't mean Southern former Confederate soldiers running rampant, even if they wear a badge. Federalism is about state and local lawmaking, democracy. So I put these together and I say the 14th Amendment requires the states to protect the natural right to be free from arbitrary searches and seizures through whatever particular positive law manifestations of that right they see fit, as determined by ordinary lawmaking, statutory and common law, and what we call administrative. They didn't really use that term. So what they had in mind was that the state positive law protections of natural rights to be free from arbitrary searches and seizures would set those positive law protections would satisfy the 14th Amendment if, but only if, they're non-discriminatory on their face and as enforced, they're actually obeyed by state agents, and they don't provide state agents with excessive discretion, what I call the principles of non-discrimination, legality, and non-delegation. Right? So non-discrimination is fairly obvious. I won't belabor the point. What is more important for Fourth Amendment purposes is legality. Search and seizure activity has to be authorized by and consistent with the law, either through laws of general application, such as the law against trespass. Police have to obey the same law against trespass that the rest of us have to obey. Or there might be special authorization. The law might say, you can't trespass except that the police can do such and such. If there's specific legislative authorization, then you've satisfied the legality principle And then you have to look at non-delegation. Does the law provide excessive discretion to the police? And there's really two concerns here. There's excessive discretion, excessive delegations from legislatures to executives, and excessive delegations within the executive branch, right? So the first one is what we're familiar with when we talk about the non-delegation doctrine. Non-delegation isn't just about separation of powers. Non-delegation is also about due process and the rule of law. And due process is really in part about separation of powers. So you can't have the legislature just give a blank check to the police. You also, at the second stage, you also can't have the individual officer on the street exercising too much discretion, even if the legislature has sort of narrowed it for the police department as a whole. The individual officer on the street has to have their discretion cabined to a certain extent. So let's look at these principles in action. Those who teach Prim Pro are undoubtedly familiar with Michigan Department of State Police versus SITS. If you're not, it's the case where the Supreme Court said sobriety checkpoints are okay. Police can just stop people and make sure that they're sober as long as they stop, every car or every fifth car or every 10th car or whatever it is. Well, that satisfies the principle of non-discrimination. That's easy, right? They're stopping everybody, or they're stopping every third car. They're not distinguishing among. They're not stopping only the people of color. They're not stopping only the cars that look more than 10 years old, right? This is applied very equally. So there's non-discrimination. Unfortunately, for Michigan, I would say there was a legality problem because checkpoints were not authorized by Michigan law. If you read the Michigan law that could be relevant, it says basically says police have the authority to enforce the law. That doesn't specifically authorize sobriety checkpoints. Whereas a state like New Hampshire says that sobriety checkpoints are authorized if the law enforcement officer or agency petitions the Superior Court and the court issues an order authorizing the sobriety checkpoint. Whoops, let me get that out of there. After determining that the sobriety checkpoint is warranted and the proposed method of stopping vehicles satisfies constitutional guarantees, right? So that's good for New Hampshire. But when it comes to non-delegation, well, not so good, right? Because that statute doesn't tell us anything. It just kind of shifts the burden to a judge to say you have to make sure these checkpoints are warranted, whatever that means, right? But we do have states like Iowa and Utah. I put the Iowa statute up here that in their statute, they specifically authorize sobriety checkpoints. And they also say, what has to be done, what has to be delineated in the order, setting out the checkpoint scheme. So my argument is that a detailed scheme like this, a statutory or administrative scheme that sufficiently reduces police discretion should often be enough to satisfy due process principles, even when, and this is important, even when police are looking for evidence of a crime. So police have said, the Supreme Court has said sobriety checkpoints, yes, narcotics checkpoints, no, because that's just ordinary law enforcement. And my reaction is, what's the difference? You're doing the same thing. You're stopping people. You're stopping every fifth car. You're eliminating police discretion. What difference does it make what they're looking for? It also means that when police are performing what I call functions ancillary to the law enforcement function, such as searches incident to arrest, right? They're performing a law enforcement function, but they're doing something sort of administrative or safety oriented. They're trying to make sure that the person doesn't have a weapon, doesn't have evidence that they're going to destroy. A detailed statutory or administrative scheme that sufficiently reduces police discretion can replace the judicial oversight that we've seen in case after case after case, where the Supreme Court kind of micromanages what a search incident to arrest is. So the Supreme Court has kind of gone back and forth between judicial micromanagement and judicial abdication. And I think there's a middle position that we can have detailed administrative or statutory schemes in place that will they'll do the job of eliminating, or not eliminating, but reducing police officer discretion. So that's chapter 11. I talk about 4 particular problems of modern policing, what I call the panopticon problem, encroaching technology that isn't necessarily considered a search under current Fourth Amendment law, and so the Fourth Amendment wouldn't apply. The problem of traffic stops and arrests, traffic stops and arrests for minor offenses, and the stop and frisk problem are both about too much officer discretion. Everybody violates the traffic laws, and the police basically have carte blanche to stop anyone they want. Stop and frisk is similar. The standard for reasonable suspicion is so low that reasonable suspicion can exist almost anywhere. And then I end the book with what's been kind of in the headlines the last couple of years, not just the last couple of years. Some of us remember Rodney King, but the problem of unjustified police violence. So what do I say? I'll go through this quickly because I'm kind of sort of running short on time. The technology problem, well, that's really a question of legality. It's mostly a question of legality. Police should be able to use these technologies if we let them, if they have legislation, if there's specific legislation authorizing them to use particular technology, then that satisfies legality, and they still have to obey the sort of non-delegation principle. They can't have unbridled discretion to use the technology. They can use the technology that we all have, right? They can use binoculars, let's say, but they can't use binoculars to peer into someone's bedroom because I can't do that. That's a tort, and in many places that's a crime, right? So it's not so much technology based, but it's how you use the technology. Like I said, since everybody speeds, police have unbridled discretion really to stop anyone they want. One thing we can do is eliminate traffic stops pretty much across the board and rely on existing and emerging technologies, red light cameras, speeding cameras, manufacturer installed monitoring of autos. And I know we get pushback on things like red light cameras. We get pushback from people who look like me, to be honest, people who are the beneficiaries of police discretion, right? And that's what we're trying to get at, is to reduce that police discretion. Or we could sort of go the other way, require traffic stops. If certain criteria are met, someone's going a particular number of miles per hour over the speed limit, or require stops, even if someone is going 1 mile an hour over the speed limit. As long as we can all agree on that, as long as we're willing to face the consequences, that's fine. Reasonable suspicion, like I said, is a very low standard. All of these have a racial dimension, by the way. I think that's obvious. Terry versus Ohio, which was the progenitor of our stop and frisk jurisprudence, was about dangerous conduct that was about to occur. It was about an armed robbery that was about to occur. And stop and frisk has now morphed into and expanded into a general crime fighting technique. Someone on the street looks sort of generally suspicious. Police can point to 1 or 2 factors that are objective, that and can articulate that suspicion. They can stop that person, detain them, arguably frisk them, and it should be limited to its roots. It should be about exigencies. And then finally, the problem of police violence, which I wrote in the book. I also wrote a sort of a follow-up piece in my own law review for a symposium earlier this year. When police violate the law, they should be prosecuted. I mean, that seems fairly straightforward. They're entitled to the same self-defense and defense of others principles as the rest of us. They're even entitled to a special law enforcement defense that use of force is justified if it's necessary. But unfortunately, prosecutors have given police a pass in many cases. It's starting to get better, obviously, with the George Floyd incident and others. But courts and prosecutors should not add to the defenses that the police have. I think I'm a little bit over time, so I will end there. Thank you.
Thank you, Michael. All right, so our final presenter will be Samantha Barbas, and she has written a new history of one of the most famous constitutional law cases there is. And I'm also going to share a slide for her at the appropriate point, and I hope I don't mess it up. So if I do mess it up, I apologize. But I'm going to try to get it right. So with that said, Samantha, you're welcome to start.
Thank you. So my book is on New York Times versus Sullivan. And I think it's safe to say that Sullivan is a case that not only everyone here knows about, but that the general public has come to know as well in recent months and years. The 1964 Supreme Court decision in Sullivan established the actual malice rule in libel law. So as a matter of First Amendment law, a public official suing for libel must show that a defamatory statement was false and that the speaker made the statement knowing that it was false or with reckless disregard of whether it was false or not. By imposing constitutional limitations on the libel tort, the Supreme Court in Sullivan revolutionized First Amendment law and also libel law. The past few years have seen several high-profile attacks on Sullivan, including proposed legislation in Florida that would have rolled back the protections of Sullivan, numerous attacks on Sullivan by Donald Trump and others, discussion of Sullivan in the context of Dominion versus Fox News, and various other controversies, which have all generated a good deal of popular interest in and perhaps some sentiment against New York Times versus Sullivan. Most law professors and law students know that Sullivan came out of the civil rights movement of the 1960s, but Sullivan is taught as a free speech case. It's been enshrined in popular memory exclusively as a First Amendment case, and it's usually described by the press as a case about freedom of the press. So I want to suggest that Sullivan should be understood as a civil rights case as much as a free speech or freedom of the press case. I think it's impossible to understand Sullivan and its meaning and its legal and historical impacts without understanding its civil rights context. So that's the story that I want to tell today and the story that I tell in my book, New York Times versus Sullivan, as a civil rights story. So Sullivan was a case about libel. The libel tort, which dates back to medieval England, addresses injury to reputation. Traditionally, libel law was weighted in favor of the plaintiff. A defamatory statement was presumed to be false, and the burden was on the defendant to prove the statement true, completely and in all its particulars. Libel was a strict liability tort. And before 1964, the Supreme Court had said repeatedly that defamatory statements were unprotected by the First Amendment. The events of New York Times versus Sullivan began in 1960. And the New York Times was then the nation's newspaper of record, as it remains. Interestingly, libel suits were not a major problem for the New York Times before 1960. Like most major newspapers, the Times had an elaborate system in place to prevent and to defeat libel claims. The Times used these specialized libel attorneys, and it conducted extensive fact-checking. So the Times could publish somewhat freely by taking these precautions. It would seem, quipped one of the Times lawyers, that if anyone had an idea of getting rich quick, he would be better off looking for uranium than suing the New York Times for libel. Nevertheless, libel remained a latent threat to the press, as the New York Times would soon discover. The New York Times was the leading newspaper covering the civil rights movement in the 1950s. The New York Times had actually been the first national news outlet to have a full-time reporter in the South, starting in 1947. The New York Times was regarded as the nation's most comprehensive source of news about the civil rights movement. By 1956, after the Montgomery bus boycott, most of the major news outlets had followed the lead of the Times and put reporters in the South. So this influx of journalists was greatly resented by segregationists and likened to an invasion. Segregationists feared the power of the press, its power to influence public opinion, and with good reason. The mass media were at the peak of their influence and prestige in the 1950s and 60s. Media coverage of civil rights protests and the often violent backlash that they generated would prove critically important in building national support for civil rights that led to the passage of the Civil Rights Act of 1964. So the civil rights movement needed media coverage. It needed the New York Times, it needed NBC, it needed Life magazine to illuminate for a national audience the cruelties of the Southern racial system and the courage of those who defied it. The segregationists waged a fierce war on the Northern press in an attempt to intimidate it and deter it from covering the civil rights movement. So reporters were beaten and assaulted by mobs, cameras were smashed. Another weapon was libel suits. Segregationist officials realized that libel lawsuits governed by these plaintiff-friendly rules could be used to threaten and to terrorize and even to bankrupt media outlets that covered civil rights. So the principal target of this libel attack would be the New York Times, which segregationists deemed to be the worst offender of the so-called lying Yankee press. So the events that started New York Times versus Sullivan began in 1960 with the famous lunch counter sit-in in Greensboro, North Carolina. And within weeks, students had staged similar protests throughout the South. The sit-ins reached Montgomery, Alabama that spring, and white mobs retaliated against the civil rights protesters, many of whom were students at the local Alabama State College. Police Commissioner L.B. Sullivan permitted mobs to attack the protesters while the police stood by and watched. So not long after this incident, a civil rights group called the Committee to Defend Martin Luther King and the Struggle for Freedom in the South published an advertisement in the New York Times describing these acts of brutality against civil rights activists in Montgomery and various other Southern cities. So this ad was intended to generate contributions to assist the sit-in protesters, and also for the defense of Martin Luther King, who had recently been brought up on phony charges of tax evasion in Alabama. This was part of the tactic of the segregationists of using the legal system to undermine the civil rights movement. So this ad ran in the New York Times in March 1960 under the title "Heed Their Rising Voices." And listed at the bottom of the ad as endorsers were the names of 64 eminent figures in the arts and politics, and also 20 ministers involved with the Southern Christian Leadership Conference, Martin Luther King's organization, and one of the major civil rights organizations of the time. So it turned out that this ad contained minor errors. The ad reported incorrectly the names of songs that students had sung on the Capitol steps in Montgomery. The ad alleged that officials padlocked the dining hall of the college to starve and punish the protesters, which wasn't true. It said that King had been arrested 7 times when he had only been arrested 4 times. So there were some errors in this ad. The New York Times had failed to follow its policy of checking the accuracy of all of the text that appeared in the newspaper, including advertisements. A lawyer in Montgomery named Roland Nachman saw this ad and encouraged 3 local officials, including L.B. Sullivan, to sue the Times and 4 leaders of the Southern Christian Leadership Conference whose names had appeared on the ad as endorsers. Although importantly, they didn't actually endorse the ad or even know that their names were on it. Their names had been put in the ad without their consent by the Committee to Defend Martin Luther King. So the Alabama officials sued on the theory that the ad had defamed them insofar as it accused them of engaging in brutality against the protesters. Now, none of the officials were mentioned by name in the ad. The ad referred generally to the police and to authorities. Moreover, being known for committing brutality against civil rights protesters would have enhanced the reputations of authorities in the South at the time. Yet a defamatory statement was presumed to be harmful, and the only defense was to show the truth of the statement completely, which the Times could not do. So here the segregationists believed was a wonderful opportunity to use libel law to destroy the New York Times and the Southern Christian Leadership Conference. So the statements were true in their overall gist. The Montgomery officials had, in fact, abetted and committed violence against the civil rights protesters, although perhaps not all of the specific acts that they were accused of. L.B. Sullivan and 3 other Montgomery officials each sued the Times and the civil rights leaders for $500,000. So by 1960, the New York Times was facing $7 million in damages and 5 libel suits brought over this ad, including one by Alabama's governor, John Patterson. Shortly after, 7 officials in Birmingham, including the notorious Bull Connor, sued the New York Times for $11 million over the Times' truthful reporting on official violence against civil rights activists in that city. So these libel suits were essentially an official state-sponsored attack on the press and on the civil rights movement in the guise of private libel suits. So through these lawsuits, the Alabama officials intended to let not only the Times, but the entire Northern press know that it faced libel suits if it covered civil rights or if it supported integration. As a result of these libel suits, the New York Times literally faced the possibility of bankruptcy. The officials also intended to quash the Southern Christian Leadership Conference. Never before in American history had there been a coordinated official conspiracy of this magnitude to use libel law to undermine and to destroy a disfavored newspaper and a social movement. So in a historic move, the New York Times took its reporters out of Alabama to avoid further libel trouble. As a result of the libel suits, the New York Times had no journalists on the ground in Alabama, which was one of the most important sites of civil rights activity during crucial years of the civil rights movement. Several other newspapers followed suit and took their reporters out of Alabama. So indeed, the libel suits were having a chilling effect on the press. The first libel case to go to trial, that of L.B. Sullivan, was heard before an all-white jury in the segregated courtroom of Judge Walter Burgwin Jones, who was the most extreme segregationist on the Alabama bench. The trial took place on the same day as a celebration of the 100th anniversary of the Confederacy that was being held in Montgomery, and some of the participants actually went into the courtroom dressed in their Confederate uniforms. Since the New York Times admitted that parts of the ad were false, and since the words implicating Sullivan in misconduct were defamatory as a matter of law, Sullivan's lawyers needed only to show that the statements referred to Sullivan so that readers would think of Sullivan when they read about the police. Not surprisingly, the jury concluded that the statements referred to Sullivan and awarded him $500,000, which is the largest libel verdict in American history to that time. As the Chicago Tribune noted, even the most intrepid publisher must be intimidated into silence. This threat to the press was intensified when a Times journalist was brought up on charges of criminal libel in Birmingham. So now journalists were risking imprisonment for writing critically about segregation and racial violence in the South. The success of Sullivan's lawsuit spurred a wave of copycat lawsuits. A number of Southern officials followed Sullivan's lead and filed libel suits against the press. So there wasn't just one libel suit or even a handful of libel suits. There was this massive regional attack on the press. By 1964, officials in 3 Southern states had brought 17 high-value libel suits against national media outlets like CBS and the Saturday Evening Post over their civil rights coverage, seeking damages of more than $288 million. CBS actually would have stopped covering the civil rights movement if Sullivan's judgment hadn't been reversed. The news media chronicled this attack on the press, but the impact of the libel suits on the civil rights movement has not really been documented. And that was one thing I tried to do in my book. The Alabama officials sued the most prominent leaders of the civil rights movement: Ralph Abernathy, Solomon Say, Fred Shuttlesworth, and Joseph Lowry. The Southern Christian Leadership Conference was paying for the defense of the ministers, and that grassroots organization was hemorrhaging money in these libel cases, just as the segregationists intended. The SCLC could not progress in its aims and its projects, including the freedom rides and the sit-ins, if its leaders were saddled with these multi-million-dollar libel judgments and defensive litigation battles. Martin Luther King was convinced that the libel suits threatened the SCLC's very existence. He described them as a civil rights crisis and vowed to defeat them at all costs. One of the greatest indignities in this story occurred when the Alabama authorities seized the property of the ministers to pay the libel judgments. So they took Shuttlesworth's used Buick, they took farmland that Abernathy's family had owned for generations. King described the libel suits as a weapon against the civil rights movement. He said the misuse of legal process is a new and potent weapon in the arsenal of the segregationists. After the New York Times quite predictably lost its appeal to the Alabama Supreme Court, it had to decide whether to appeal to the US Supreme Court, and this was risky. The Warren Court was not yet a reliable guardian of free speech. Clear and present danger rule, the reigning rule since the 1930s, had been badly undercut by the court's decisions against communists during the Red Scare of the 50s. Of course, the Warren Court was a staunch advocate of civil rights. The New York Times had a longstanding policy of not settling libel cases, but it was tempted to settle this time because the law was clearly not on their side. They were convinced to appeal by Herbert Wexler, an eminent Columbia law professor whom the Times had hired to represent them. And Wexler convinced the newspaper that it should appeal. He said, if they settled, what would happen in the next round of libel cases that would inevitably be brought by Southern officials against the New York Times? So Wexler convinced the leaders of the Times that there was an important freedom of the press issue at stake and that the Times owed it to journalism to make a claim before the Supreme Court that strict libel laws infringed on freedom of speech, particularly as it applied to criticism of public officials. But how would Wexler get around this problem that libel law did not raise a constitutional issue? Well, Wexler came up with a brilliant strategy, and that was to shift the main issue in the case from the right to protect individual reputation to the right to criticize government. Wexler argued that Alabama's libel law, which permitted an official to recover damages for, quote, a publication critical of conduct of a government agency under the official supervision, unless the jury is persuaded that the statement is entirely true, he said that was indistinguishable from the proscriptions of seditious libel, the old and defunct crime of criticizing the government, which long had been assumed to be unconstitutional. So Wexler makes the sweeping argument that criticism of public officials in their official capacity is protected entirely by the First Amendment, even if false and defamatory and intentional. The ministers pursued a separate appeal. They alleged that the trial in a segregated courtroom and the libel prosecutions themselves were motivated by racial animus. So it isn't difficult to figure out why the Supreme Court decided to take this case. This libel attack represented another example of Southern intransigence and resistance to the court's integration mandates. This libel attack threatened to undermine the work of the press in facilitating the civil rights movement. The justices considered the petitions in the spring of 1963 as newspapers and TV screens flashed with images of protesters, including young children, being attacked by police dogs in Birmingham. Memoranda in the justices' papers in the Library of Congress suggest that concern for the civil rights movement was a main reason for the court's engagement with the case. Justices were all aware of the slew of libel cases that were coming up from the South, and they were aware of the chilling effect that this was having on news coverage of the civil rights movement. Some of the justices were also interested in the free speech issues presented in the case. So the relationship between libel and the First Amendment was a question that the court had not engaged with to that time. And there were some on the court who thought that it was time to take up that issue. So all the justices were clear that Sullivan's judgment had to be reversed, but they didn't agree on the grounds for reversal. Hugo Black and William Douglas, who were free speech absolutists, supported Wexler's broad argument that the case involved criticism of public officials, which was completely protected. But the other justices weren't willing to go that far, and they thought that the right of reputation should be balanced against the right of free speech. Chief Justice Warren asked Justice Brennan to write the opinion. And Brennan, of course, was a noted advocate of civil rights and also a leading justice on the First Amendment. Brennan was known as a master at compromise. So when Warren often called on Brennan to draft opinions in high-profile cases where the justices were clear on the outcome that they wanted to achieve, but they weren't sure on how to get there. Justice Brennan wrote 8 drafts of the Sullivan opinion over 2 months and held a majority on the main rule of the case, actual malice, which was used to strike down the judgment against the New York Times and the ministers. Wexler actually had not argued the actual malice rule. Something like actual malice appeared only in passing in the New York Times brief. Justice Brennan invented actual malice as a compromise to win a majority to please both the absolutists and those who preferred balancing approaches to the First Amendment. So actual malice provides broad protections for speakers. Also, it provides protection for reputation. Brennan was very conscious of what it would take to get the New York Times off the hook in this case. He knew that a negligence standard would not have protected the Times, since the Times admitted that it had been careless in publishing the ad without checking the facts. So in its unanimous opinion, the court reversed Sullivan's verdict, shifted the balance between the protection of free speech and the protection of reputation, and undertook a major shift in its thinking about the First Amendment. Brennan's opinion identified a central meaning of the First Amendment, the protection of the right of citizens to criticize the government, and declared famously a national commitment to uninhibited, robust, and wide open debate of public issues. This forceful articulation of the role of freedom of speech and democracy lay the groundwork for the court's expansion of the First Amendment in coming years. New York Times versus Sullivan saved the nation's newspaper of record and transformed the workings of the press. Sullivan freed the Southern Christian Leadership Conference from the burden of the libel suits, which had taxed its resources for nearly 3 years. Sullivan turned back Alabama's libel attack and enabled robust reporting on civil rights. Coverage of protests in Selma, Alabama the following year helped to facilitate the national consensus on civil rights that led to the Voting Rights Act of 1965. So insofar as the success of the civil rights movement can be attributed to direct action protests and media coverage of those protests, Sullivan was one of the most crucial decisions facilitating the advance of the civil rights movement. But New York Times versus Sullivan hasn't survived in legal doctrine and history as a civil rights case. Its principal legacy is as a case about freedom of expression, particularly freedom of the press. I think this reflects in part the New York Times strategy of subduing the case's civil rights dimensions, which it actually thought might work against it. Wexler also wanted to achieve a ruling that he thought would protect speakers outside the civil rights context. And so he framed his arguments very broadly. Justice Brennan also felt that way, it appears. There are almost no mentions of civil rights in the New York Times versus Sullivan opinion. The press memorialized Sullivan as a press case. None of the media coverage of the decision in 1964 mentioned the minister's case. Sullivan was further distanced from its civil rights context when actual malice began to be applied to libel cases that had nothing to do with civil rights and even to areas of law beyond libel. And as Sullivan's tributes to free expression came to stand for general First Amendment principles. So Sullivan is taught as a First Amendment case, and it hasn't been included in the major histories of the civil rights movement. So I think this diminishment of the civil rights context has impoverished our understanding of the history of civil rights and also the history of the First Amendment. I think it obscures how much the development of free speech law was influenced by the civil rights movement. in cases involving the civil rights movement, such as Sullivan and NAACP versus Alabama, the court began forging a body of First Amendment law that was highly protective of the rights of dissenters to resist government intimidation. I think situating Sullivan in its civil rights context would also underscore how the press is not the only beneficiary of Sullivan. I think Sullivan has become so identified with the press that attacking Sullivan has become synonymous with attacking the press. In an anti-press era, I think the characterization of Sullivan as a press case could actually threaten Sullivan. Critics have tried to harness public opinion against the press to undermine Sullivan. It is true that overruling or modifying Sullivan would potentially undermine the press, but Sullivan is not a special subsidy for the press, as it is often portrayed. As the case of the ministers illustrates, overruling or modifying Sullivan would undermine the free expression of everyone, including individual critics seeking to speak out against the status quo. So in conclusion, I think it's essential to situate Sullivan within its context and within its times. So I invite you to consider Sullivan not only as a First Amendment case, but also as a civil rights story. Thank you.
Okay, well, thank you, Samantha. And thanks to all the presenters. The subjects of the books are different, but the quality is the same. It's all high quality. What I'm going to do now is open it up for questions, and there are some questions in the queue. And as I said at the beginning, you can put your questions in the chat. You can raise your hand with the little button, or you can just literally raise your hand like that. So, but what I'll do is I'll just read one from the queue. So the first one is going to be for Kermit. Okay, so here's the question. There's some background to it. The U.S. Supreme Court consistently has ruled, at least until about 40 years ago, that the Constitution enforces the Declaration. Chief Justice Berger, of all people, wrote in an article, quote, "The Declaration was the promise. The Constitution was the fulfillment." I take it the courts simply are wrong, caught up in the romance of the Declaration. So I think the questioner would just like you to react to that.
Yeah, so I mean, the relationship between the Constitution and the Declaration is complicated and interesting, and what courts have said about it, I think, is very interesting. But so my general answer to that would be, this is a common idea. This is something that Abraham Lincoln says too. Lincoln says, the Declaration is the apple of gold, and the Constitution is the frame of silver, and the Declaration is the spirit, and the Constitution is the law. And it's part of the story, as I said, right? We've got these ideals that are stated in the Declaration, and then they're made into law by the Constitution. And what I have been trying to say is that's not really true about the Declaration as it's understood in 1776, because it doesn't have the ideals that we now attribute to it. And it's not really true about the Constitution written in 1787, even if you add in the Bill of Rights in 1791, because that's not really protecting the natural rights of individuals. It does all sort of become true later when you get to Reconstruction. Although, as John Witt has pointed out, the 14th Amendment is sort of an ending as well as a beginning, because the moment when the federal government is really protecting the natural rights of individuals from other individuals is before the 14th Amendment, when you've got U.S. troops in the South providing protection to the formerly enslaved. But the 14th Amendment moves the federal government in the direction, constitutionally speaking, of protecting individual natural rights. And in that sense, it is actually enforcing the Declaration, you could say. So, what I say about a lot of this is the story is sort of true, but not quite in the way we think, and we have to look at different moments. And in terms of the source of the ideals, I would suggest looking at different texts. Like, I would rather look at the Gettysburg Address than the Declaration of Independence.
Okay, well, thank you. And so here's one for Ilya. And Ilya mentioned that you wrote an update during the pandemic. And so when the pandemic first started, we had Donald J. Trump as the president. And so this question kind of relates to that. So here it is. In your book, you implicitly deny the right of a nation state to exclude non-citizens from its borders. By not permitting exclusion, isn't an important aspect of freedom lost, namely the ability of individuals in combination to bring about public good type outcomes, examples of which include, among other things, language protection, environmental preservation, and the protection of common resources?
So it's an interesting question. Let me first say, I don't just implicitly deny it, I explicitly deny it. I say there is no general right of governments to exclude people simply on the basis that they're non-citizens. There might be extreme circumstances where they could exclude people for other kinds of reasons, like they're planning to commit an act of terrorism or the like, where you could actually restrict the freedom movement of a citizen as well in those circumstances. Now, there's a whole bunch of specific examples given there, but I'll start out with a point of general theory, which is that it is a mistake to equate governments with individuals acting together on a consensual basis, because despite what the Declaration of Independence says about government by consent, no actual government actually is fully consensual. They all exercise power over large numbers of people who did not have a meaningful opportunity to reject that authority, and therefore we should not assume that governments have all those powers to exclude that would be available to, say, private property owners or a fully voluntary private organization. I go into this in more detail in the book when I criticize the analogy between governments and private clubs or private homeowners. Private homeowners or private clubs have general right to exclude. Often they don't even have to have a particularly good reason. They can just say, well, I don't particularly like Scott Gerber, so I don't want him to come to my house. I just don't like him. I don't have to have a good reason. And a private homeowner can do this. I can also have like the non-Scott Gerber private club where everybody I invite can be a member. Anybody can be a member, but not Scott. Governments, if they have those powers, that would mean drastic constraints on the liberty, not just of immigrants, but also of natives. Among other things, a private club or a private homeowner on their property, they can say only the religion that we like can be practiced, only pro-Republican or pro-democratic speech, and so forth. The other parts of the question relate not so much to a general right to exclude, but to specific issues like environmental preservation and a couple others. In the book, I argue at some length that those kinds of things, and I go through all the examples listed plus some others, should be dealt with a three-part framework. One is, you ask, is there actually a genuine problem that's caused by migration? In many situations, the answer is no. In particular, the extra wealth created by migration, for example, actually furthers environmental preservation rather than diminishes it. And the same thing is true for a lot of other claims about negative effects of migration. For example, immigration into the US actually reduces the crime rate rather than increases it. But second, let's say there is a genuine problem. We can ask, is there a way of addressing it through ways other than excluding migrants? What in the literature is called keyhole solutions, and very often, almost always, the answer is yes. Third, let's say that there is a problem, but there is no way to address it through a keyhole solution. Still, free migration creates vast new wealth. I mentioned in my presentation people moving to areas where they get more opportunity. That also makes them more productive and makes native-born citizens more productive and wealthy as well. Economists estimate that if we had free migration throughout the world, we would double world GDP. That is, the world would be twice as productive as it currently is. That's a huge, enormous amount of wealth that can be used where necessary. Some of it can be used to address potential negative side effects of migration. So when you add it all up, I don't categorically exclude the possibility there can be circumstances where there's some grave problem created by migration that can only be addressed through exclusion, but such circumstances are likely to be extremely rare, and they certainly don't justify anything like the existing system of migration restrictions. And I would add that all of those justifications are usually given for them, if taken seriously, almost all of them would justify severe restrictions on internal freedom of movement as well. People moving from one state to another can compete for jobs. They might become bad voters and vote for bad public policies. They might have problematic cultural values. They might speak languages that we don't like, and so on. And so I think that's a slightly lengthy response, but the question covered a lot of issues, and every one of them I do in fact talk about at greater length in the book, particularly in chapters 5 and 6. So thank you for that.
Okay. Here's one for Michael. One of the most important lessons of your book is the need to limit police discretion. Why do you feel so strongly about the need to limit police discretion?
So thank you for that. I think it's the reason I give in the book is that it is implicit in the concept of due process of law that state officials follow. To put it in originalist terms, one of the problems that as I said, the Reconstruction era Republicans had with what was going on in the immediate post-war South were the vagrancy statutes. And vagrancy statutes have a long pedigree. They date back to, I think, the 14th century in England. But the southern states had repassed vagrancy statutes to put in provisions allowing basically the convict leasing system to begin. So that person was convicted of vagrancy, they couldn't pay the fine, they would be leased out, their labor would be leased out for the year. The reason the vagrancy statutes, it wasn't just because it was the foundation of a convict leasing system. The reason the vagrancy statutes were so abhorrent was that they were being arbitrarily enforced. And there's lots of evidence that white people in the South were no less likely than Black people in the South to just be standing around, not doing anything, but vagrancy statutes were almost invariably enforced against Black people. And it is, if we make the analogy today, we can think of traffic offenses as the current incarnation of vagrancy statutes. Everybody speeds, let's say. There was a report on the New Jersey Turnpike in the early 90s that I think it was 98.1% of the cars on this particular section of the New Jersey Turnpike were speeding. I guess that's not surprising if you've ever been to New Jersey. So police have this inordinate, universe of people they can stop, all but the very law-abiding 1.9%. And they can use that discretion in essence to make law rather than to enforce it, to say, I'm going to stop people who are speeding, plus they look like this, or their car looks like this, or I just have some kind of inarticulable hunch that they might be carrying drugs. So that's sort of the historical basis. I also talk about a representation reinforcing basis, and the two mesh up. I think that what the framers and ratifiers of the 14th Amendment meant by due process of law was something like Ilya's representation reinforcing idea that if you give police discretion, you really can't trust the political process, right? If you can't trust the political process to say that 55 miles an hour is the ideal maximum speed limit, because we know police have this discretion, and we know that the people who would otherwise vote for legislators to raise the speed limit. We know that those people are not going to be the ones who are getting stopped by the police. If the police have very limited discretion, and let's say we tell them you have to stop everybody who's speeding, well, that's never going to happen, right? Because as soon as it starts happening, as soon as state legislators start getting angry phone calls from their upper and middle class white citizens saying, hey, I keep getting a speeding ticket every time I go to the grocery store because I'm going 36 miles an hour rather than 35, that law is going to change, or the enforcement policy is going to change. Those are basically the two reasons I give.
Okay, well, thank you. And here's a long one for Samantha. Okay, so Justice Thomas has disparaged Sullivan and its progeny as, quote, policy-driven decisions masquerading as constitutional law, because making a plaintiff prove that a defendant had a reckless disregard for the truth is inconsistent with the founding era common law of libel, which lacked a heightened liability standard and often presumed the defendant's malice. In another case, Justice Thomas asserted that the common law traditionally treated lies about public figures as more troubling than lies about ordinary people, and so, inverting the logic of Sullivan, public figures may deserve more protection, not less. What do you think of Thomas's arguments against Sullivan?
Just say that this is a very challenging question for me with, my, I'll say, 20th century understanding of the law of libel. But I will say probably as a factual matter, I think it is correct, that certainly the common law offered fairly robust protection for reputations, including the protection of the reputations of public officials, right, on the theory that we needed to keep our officials on a pedestal in order, to ensure that they commanded authority and that it was no good for the public if their reputations were besmirched. Historically, I think these are valid arguments, but whether, the pre-Sullivan law of libel wasn't, sort of quashing the kind of public information that, we needed about issues, such as civil rights. And, it's very difficult for me to weigh in on Thomas's point.
Okay. Here's a historiographic question for Kermit. Your book contains a bibliographical essay at the end. A lot has been written about the Declaration, the Constitution, and the Reconstruction Amendments. How did you decide what to read and or cite and what not to read and or cite in your book?
Well, I wouldn't say that I had any sort of overarching philosophy on that. Basically what I usually do is, I read the primary sources, I think about them, and then I try to look for things that address the questions that come up. And I just sort of let the research lead me. So, one thing will lead me to another. One of the places I started actually was Professor Gerber's To Secure These Rights, which has a great variety of views and a good selection of essays on the Declaration of Independence. So I started with sort of the things that were ready to hand, and I tried to follow them in the directions that they pointed, and the arguments that they accepted, and the arguments that they rejected. And it's not really possible probably to read everything that's ever been written. So, there are certainly things that I have left out. But basically what I was doing was I was trying to follow the trail down the paths that I was trying to say something about.
Okay. All right. So we have time for about two more. And I have more than two more, but if anyone else wants to ask one, please do it now. So I'll pause for like 15 seconds. And then I have one for Ilya that I want him to answer if no one else has one for Ilya. Okay, so Ilya, here's another question for you. Does foot voting damage the constitutional and political institutions of the countries migrants seek to leave?
Yeah, so this is a question I talk about at some length in the book, but didn't include in the presentation because of time constraints. And what I do is I respond to this on two levels. One is a moral level. Even if it is the case that people leaving a country damages institutions or the economy or something else, it is still wrong to force them to stay. Those people are not owned by the governor of their home country or by the other citizens of that country. And they have the right to decide for themselves where they wish to live. And there are rare exceptions to that I note, such as if a person is actually greatly responsible for the unjust institutions of their home country, like if they're the dictator or something, it might then be justifiable to force the dictator to stay and fix the mess that he created. But for the average citizen, it would be unjust to keep them in, just as it would also be unjust to make them perform forced labor, even if the forced labor would be valuable for the political or other institutions of the country. Secondly, I addressed the question a more sort of pragmatic level, which is that out-migration often can actually benefit institutions. One is that a country that has a diaspora in more liberal societies, there's evidence that that leads to greater interchange of ideas and to pressure for liberalization back in the country of origin. It's not perfect, doesn't always work, but it does have an effect at the margin. Second, with some poor nations that have a large diaspora, the relatives of the people have relatives in wealthier nations, they send back remittances, which help raise the standard of living and also make it easier for people to engage in independent political action because they're less dependent on what could be an unjust or oppressive home government. So overall, it is not actually the case that out-migration damages institutions. However, even if it did, it would still be unjust to prevent it. And I would note that this argument also applies to domestic migration as well. Badly governed cities like Detroit often lose people to migration to elsewhere in the US. You could say we should compel those people to stay in Detroit and fix Detroit's political institutions, but for obvious reasons, it would be unjust to do so. And the same thing applies to forcing people to stay in Cuba or in Russia or in other badly flawed or oppressive governments. Indeed, being forced to stay in Cuba or Russia is actually much worse than being forced to stay in Detroit. So if the one is unjustifiable, so is the other.
Okay, well, thank you. I think that's all the time we have for questions. I just want to say one or two things as we adjourn. First of all, I want to thank the Association of American Law Schools, especially the Constitutional Law section of the ALS, for sponsoring this. I want to thank particularly Shannon Leonard for doing all the technology and being so good with keeping us reminded about what we had to do and when we had to do it. Obviously, I want to thank the four presenters, Professor Kermit Roosevelt, Professor Ilya Somin, Professor Michael Mannheimer, and Professor Samantha Barbas for their excellent presentations. And as I've said, I have all four books and they're all worth reading. They're very different, but they're all very interesting and well written. And I learn a lot from all of them. And I think you will as well. There'll be another one of these new book sessions sometime when the fall semester begins. It will also be sponsored by the Constitutional Law section. We haven't picked the month yet. My guess is it'll be October or November or something like that. And I think the presenters so far are Mark Graber, Steve Vladeck. I think I'm presenting, and there's someone else that my aging mind has forgotten, and I apologize for that. But I also want to thank, of course, the audience for coming and for the questions in the chat. And if there is nothing else anyone wants to say, I think we can adjourn it, but I want to thank everyone again. So thank you, everybody.
Thank you.
Thank you.
Thank you.